very, very much. I would like to invite Inge van Hulle, yes, who is currently a PhD researcher at Leuven, Belgium, under the supervision of Professor Randall Lesaffaire. Her project, funded by the Flanders Research Foundation, examines the role of Britain's imperial policy in the development of international law in Africa between 1815 and 1885. So please.
How do I go to my... Thank you for your introduction. I will start my presentation by apologizing because I put together this PowerPoint presentation last week when I was coming home from another conference in the middle of the night, and there were some mistakes in my PowerPoint, for which I apologize, so I hope you will bear with me, and at least this has empirically shown that I am more of a day person than a night person. Anyway, my talk today refers to part of my PhD research, which concerns the British prehistory, if you like, of the Scramble for Africa in the 19th century, and more particularly with a focus on international law and the laws of territorial acquisition. Now, when I talk of the Scramble for Africa, perhaps you will have this image in your mind of the map of Africa with all these colors that represent the various territories taken by European powers, of which, of course, the British territories were just one aspect. Now, like any historical event, the Scramble for Africa also has prehistory, and many of the instruments that were used by these European powers, such as treaties of cession, protectorate treaties, and sphere of influence treaties, obviously were further refined and developed prior to the Scramble for Africa. Now, the period prior to 1870, which is more or less when the Scramble for Africa began, is generally not really perceived as an imperialist time period. Now, why is this so? Well, one explanation could be that for a number of decades, actually African customary international law and European international law coexisted actually side by side. And this is going to be the main topic of my talk with you today. So I have more or less a threefold presentation. I will first take as a case study the international relations between Britain and the African indigenous people of the west coast of Africa. It says Gold Coast, but of course the Gold Coast was just a part of the west coast, and I actually wanted to put the west coast, but anyway, this is part of my night adventure. Secondly, I will then explain some aspects of African customary international law, only to illustrate then that by the middle of the 19th century already, we see that more and more aspects of European international law actually replaced African customs. Now, when we look at the map, British settlements on the west coast of Africa at the beginning of the 19th century and the end of the 18th century consisted of just a number of forts scattered along the coastline in mainly the areas of Sierra Leone, Gambia, and the Gold Coast, which is present-day Ghana. Now, the administrative history of these forts is quite complicated because their administration switched a number of times from administration by chartered merchant companies and direct control by British governor-generals. I will not go into detail of this administrative history because I don't have the time and it's also quite boring. But what is important to remember is that when you look at the map, you see that British presence was quite limited, and also infrastructure of these forts was quite limited. And in fact, British settlers and merchants lived in close proximity with indigenous African communities, mostly for purposes of trade. There was relatively little central control from London, from the Foreign Office and the Colonial Office, because it is true that London didn't have a policy of territorial expansion at the time, but also for practical purposes, because you have to imagine that sending a diplomatic dispatch from the west coast to London took on average between 3 or 4 months. So it was quite difficult to exercise direct control on the development of international law and the use of these international legal instruments from London. Well, and in this context of limited British presence and limited governmental control, Anglo-African relations at the end of the 18th century and the beginning of the 19th century were really dominated by a system of African customary international law. Now, when I speak of African customary international law is obviously it's a Western conception, and it's always tricky to transpose this concept to a non-Western context. But let me just say that I'm using this for argumentative purposes here, and that it is, well, by most scholars recognized today that there was in fact a body of unwritten rules that was recognized by these African communities on the West Coast, and that was perceived by them as binding. I can't explain everything about African customary international law, but I will highlight two major customs. The first one is the custom of palaver. And palaver is a generic term that applies to all forms of peaceful dispute settlement or diplomatic negotiations, both between private individuals and between African leaders and European negotiators. Now, palaver was surrounded by a lot of ritual. In most cases, presents would be exchanged between the African negotiators and the European negotiators to create goodwill and an opportunity to discuss whatever was going on. Palavers could take place at European headquarters, also at the African headquarters. There was in the sources, what is often described is that for the conclusion of palaver, fetish would be taken, and fetish is a kind of sacred oath that would bind the parties to the agreement together. Presents were essential, not just for these negotiations, not just for palaver, but also for various other at various other occasions. And it was a very useful tool for African communities to actually exert influence over Europeans. And the more powerful an African leader was perceived to be, the easier it would be for him to use these presents as a negotiating tool. For example, establishing commercial ties with African communities located not just on the West Coast itself, but more to the interior, was essential to create a commercial web. And for that purpose, forced paths to the interior had to be cleared, and safe passage had to be bartered with African leaders. So for that, these presents had to be exchanged. In fact, even more so, if there were no presents, then trade simply would not be permitted by African leaders with the interior. Now, gradually we see that European international law intrudes in these relations. And in that sense, the year 1807 was very much a turning point for the history of African international customary law, because it heralded two major developments. And here I go away somewhat from the structure of the slide, so please pay attention to what I'm saying, not so much to what's on the slide. So in 1807, the British Parliament actually voted in favor of the abolition of the slave trade, as some of you may know. And this was the starting point of an international campaign led by Britain to secure the worldwide abolition of the slave trade. And it also heralded a period of international legal experimentation by Britain to gain this abolition. And the most famous example, obviously, is these anti-slave trade treaties that were concluded between Britain and various powers, and the subsequent establishment of these courts of mixed commission, where captured slave vessels would be adjudicated. Now, it was, of course, one thing to convince these European powers that the slave trade had to be abolished. It was quite another thing to convince African leaders to do the same, because obviously for them it was also a very lucrative business. But since 1807, the idea had begun to grow amongst abolitionists, and particularly the Anti-Slavery Society, that a positive incentive had to be given to these African communities. And what better incentive from a British perspective would be the lure of British manufactured goods to replace this illegitimate trade. And this is where the term legitimate trade is actually born, and this is quite significant because it heralded a period during which Britain actually concluded more and more treaties with African indigenous communities for the abolition of the slave trade and to open the interior for British trade. So we see increased formalization of British-African relations through the use of treaties. Now, a second development was that in 1807, the British Crown took over the government of Sierra Leone and turned Sierra Leone into a crown colony. And this coincided with the appointment of various governor generals who were very ambitious not just in Sierra Leone, but also in Gambia and the Gold Coast. And they had a greater vision of the future for themselves personally, but also for their own territories. And this came hand in hand with increased territorial acquisition. So again, we see that more and more treaties are also concluded, but this time treaties of cession, where tracts of land would actually be ceded by African communities to the British. Now, this increased formalization through paper conventions was not entirely new, because of course the treaty, as perhaps you may not know this, but the treaty was also used in inter-African relations, so it was not just a European thing. But the difference is now that we find more instances of coercion being used during these negotiations and more unfavorable and unequal treaty stipulations on the part of these African communities. For example, where more and more extraterritorial rights would also be given to the British. Now, it is important to remember that still the official British policy was not one of territorial acquisition. Well, this did not stop these ambitious governor-generals from concluding these treaties, but what happened, and this is very interesting, is that some of these treaties were never actually ratified by the British Crown. And they ended up in this weird legal twilight where essentially the British could use them to their own advantage, while at the same time also claiming non-ratification whenever African communities demanded rights. So this was obviously, for the British, it was quite convenient. Now, the adherence to the African way of handling international law was still quite resilient, and an example of this is the Anglo-Ashanti War, which was a direct consequence of the British failure to perceive the importance of African customary international law and to adhere to it. In the end, Britain didn't actually draw a lot of conclusions from this episode. They didn't draw a lot of lessons. Generally, the British administration became more and more frustrated with African customary international law. And this is also clear from the source material. So the language towards African customary international law becomes increasingly disdainful, increasingly condescending. And this was specifically the case with respect to palaver, which was more and more perceived as tedious, as burdensome, and the same with respect to the presents that had to be continuously exchanged. So while between these years of 1807 and 1870, when the Scramble for Africa really set in, African customary international law was still used side by side with European international law, the importance of African customs is markedly diminished. And the age-old system of palaver and the payment of presents were increasingly replaced by European use of force and a conclusion of unequal treaties. And sadly, the development set up from 1807 onwards could not be stopped. And it is during this early period of the 19th century, actually, that the seeds for the Scramble of Africa were sown and African customary law received its first blows. Thank you.